Okay, so we're recording now. Welcome back, everyone. This is going to be welcome back, everyone. This is going to be a lecture on EU equality law, looking at the idea of how the EU is pushing for equality in areas of wages and discriminatory allowances between provisions prohibiting discrimination between men and women in relation to wage, in relation to age, and a few other forms of discrimination. We're going to be looking at that in a very broad sense of how the EU has brought this in through regulation, directive, and its place within the treaties across the entirety of the EU, across the 60 odd years of how this was brought in, why it was brought in, why equality of pay between men and women was one of the areas that they first brought in, and some rationale behind it. And you can see there that this lecture will be looking at Article 157 and the principle of equal pay, Article 19 and the Article 19 directives, and then the exceptions again to the rules in the case of direct discrimination of where allowances can be made. Again, looking at areas of public health, public policy, public security, but how these can relate to getting around discriminatory measures in relation to, a lot of these cases are in relation to age, for certain jobs and certain job types. So just again, these will be uploaded to Loop for an audio and a visual file. I'll put my notes up as well as a, I'm sticking a lot more to my notes in this one, so I can just upload my own notes to the slides instead of having a transcription of the audio put up. The videos I'm finding, if they go on for more than half an hour, I can't actually upload them to Loop, so I'm going to be uploading them to YouTube, and then I'll be putting the link in the Loop page so you'll be able to access that. As well, doing it this way, if you have connection errors, if you're working on your phone or if you're working in an area where you have low broadband, you can set the connection quality down and the videos won't be impacted too much. Also, YouTube is a bit more user-friendly than some of the Loop videos. I found out if I move my cup over, it disappears. But so when we're looking at this, when we're looking at the idea of EU equality law, it was originally confined to areas of equality between men and women in the area of employment. It was one of the more reasonable grounds that the member states could agree upon and bring in legislation to actually engage with. And when we're looking now, this was in the early 1970s. What we have now for discrimination is quite a broad and developed situation of what can be classified as discrimination. And this is not a set point. The idea of what can be what measures can be discriminatory is in constant flux and has to be redefined, redeveloped, re-examined in light of cultural changes. So what we can now view as discrimination can change again, and we can look at how a recognition of individuals can be, or rather than the non-recognition of individuals can be looked at as a ground for discrimination. And this is a side point of this is there was a legislation, Bill 121 in Canada, just off the top, just I'm seeing this now, in Canada the last 2 years was in relation to discrimination in relation to transgender people. Apologies if I'm using the terms incorrectly, do let me know. But it wasn't in relation to self-identification, that if you were deliberately and maliciously using the incorrect name for the individual, that could contribute to discrimination in the workplace. It was a measure that was brought in, and it did take a while to get in to show, because that goes to show how these areas of discrimination can be quite lagging behind the cultural context or cultural development, but there are attempts to be made. And with the EU, we have the treaty has established competence to combat discrimination on a number of grounds under Article 21 of the Charter of Fundamental Rights. So again, we lost one of the other rounds. It was in relation to the EU institutions and the member states that prohibit discrimination on any ground. So there is a position, and there is a strong growing position of a recognition to combat discrimination. And as I said, we're going to be looking at it under Article 157, where this is really where it all started. It all started from, sorry, didn't you email me? where it all started and the directives that have been brought in for this. And while the original directive was later amended, there are now 6 major gender equality directives in force and a range of other policy and legislative measures to help combat discrimination, help support this policy and allow member states. Article 19 then allows the EU to combat discrimination based on sex, racial or ethnic origins, religion or belief, disability, age, or sexual orientation. So that's quite a significant body of areas bodies or areas that can be protected, or measures can be brought in to combat discrimination in them. And 2 major instruments we'll be looking at are the Race Directive from 2000 and the Framework Employment Directive from 2000, where they do both adopt measures to prevent discrimination or require the member states to introduce measures to prevent discrimination in these areas. And as well as this, we'll be also looking at the significant body of case law the CJEU has developed over the last number of years, looking at equality and non-discrimination, as well as the general principle of equal treatment and non-discrimination afforded to everyone in the EU as an EU citizen and as a worker. This copy's not bad. I'm getting better ones. So first we're going to look at the idea of the Equal Pay Directive. Sorry, students are emailing me asking me with loop access. Sorry, the student is trying it. So sorry, a student was emailing me asking an issue with loop login for this class. They were in and the internet crashed and had to be logged out. But with Article 157 TFEU, we're looking at how the principle of equal pay applies. And that's just one of the first cases. This was subsequently this was seen in the original European treaties in 1957 and was interpreted and amended so that the definition of work of equal value and what work and what equal value means is quite broad, because if you're doing the same task, are you doing it with the same intensity, the same requirements? Are you doing, what does work of equal value actually mean? If you're hired in a general capacity in, say, an office, you're hired in to work in that office, but your specific tasks may differ, even though you have the exact same job. And you can see, when looking at this, the provision wasn't originally inserted. So the original Article 157 was inserted into the treaty to ensure that employers in one member state could not have a comparative advantage over those in another member state. So there was that economic rationale behind it. It was to stop discrimination in pay and ensure an internal market actually works. But the courts were quite early on quick to jump on that this isn't just an economic aspect. There is a social element of it. It does make sense for people doing the same work to be getting the same pay. And the courts are quite quick to really, as I said, put in the social side of this to show it's not just the economic, that everyone is working for the same pay. There is a social contribution to it. There is a social progressiveness to it. And with this, we're looking at it from the frame cases number 1 and case number 2, where Belgium argued that the aim of the provision was economic only to avoid discrepancies in cost price due to the employment of female labor less well paid for the same work than male labor. So Belgium were arguing that it doesn't work this way. It was just an economic game. There's no social element to it. And the court said no to this. Both in the frame 1 and 2, they were looking at it and said, Article 157 does pursue a double aim. First, in the light of different stages of development of the member states, the aim of then Article 119 is to avoid a situation in which undertakings have established in the state which have actually implemented the principle of equal pay suffer a competitive disadvantage in intra-community trading competition as compared with undertakings established in states which have not yet eliminated discrimination against women women workers as regards pay. And the court went on to say, secondly, this provision forms part of the social objectives of the union, which is not merely an economic union, but but is at the same time intended by common action to ensure social progress and seek the constant improvement of the living and working conditions of their people. So really, that is what the courts were saying. They were quite quick and quite consistent in showing this wasn't just the economic side. There is a social element, and of course, forms part of the social objectives of the union. And by saying that, they were taking a stance that this is important. And one thing to know about this is that it was only going to be going forward. It wasn't going to be a retroactive application because of how the original Article 119, now Article 157 TFEU, was crafted. And this goes to how it was understood by the member states and how it was applied, and the fact the Commission hadn't brought in the effort to actually enforce it in a retroactive approach. So it was only going in from that point forward. But that meant from any jobs coming from this point would be subject to equal treatment, but existing jobs may not have had that brought in. And you can see there in the Schroeder case then, I'm trying to keep my hands out of the screen, but the Schroeder case, they were looking at the economic and social aims appeared conflicted. And the case itself was looking at the access of part-time workers to pension schemes, and which would take precedent. Would it be the social element where there would be no discrimination between full-time and part-time workers, or would it be the economic aspect that takes precedent and thereby allowing some discrimination between the workers based on the time? And if the social aim, in this case, took priority, German law could apply equal pay principle retroactively to permit part-time workers access to the pension scheme sought. But if the economic objective took priority, Germany could prevent this to ensure that firms were not operating under less favourable conditions than competitors in other member states. So when the courts were looking at this, they did look at it from a number of ways. Court looked at this and how this developed. And in later decision, the court has repeatedly held that the right not to be discriminated on the grounds of sex is one of the most fundamental human rights whose observation the court has a duty to ensure. And this goes to the angle of the difference between part-time and full-time work, and how there was a difference between individuals employed in full-time work and part-time work. There was a significant difference in the proportion of men and women applying for these positions. So women tended to have more part-time positions, and men would have more full-time positions. So by not allowing part-time workers to have access to the pension scheme, they were disproportionately affecting women by not allowing them to have access to this pension scheme. And really the courts looked at it and said the social aspect is taking precedent, and this was in 96, so the social element has gotten stronger at this point, but it is important to note. And when we look at this, the emphasis on the human rights aspect and the social element of it over economic competitive as the primary rationale for the EU equality law is evident in the preamble to recent legislations, and we'll be looking at that a little bit later. Just how that works and how that goes forward. But it was really the courts consistently saying it's a social first and economic aspect. That while it both exist, the social element is there because it's just so important to how the EU is constructed now. I love to have a copy and class of that. So what does Article 57 actually mean? We'll have to look at the actual scope of it. And you can see there that pay is given a very wide scope. In relation to the rights of workers, we've looked at what economic remuneration in the past meant. Was it always just cash in hand at the end of a work week? You worked 40 hours, you get paid for 40 hours. Or what could pay actually mean? But in taking this broad scope, the courts actually were creating some confusion. And there was a borderline between pay and questions of social security. Where do you draw the line between the two? And some member states had some questions. And it was argued that some of the measures and some of the rulings of the European courts appeared to undermine measures adopted by the EU institutions, while others appeared responsive to the political context by retreating from earlier expansions and in the face of member states having a little bit of a hissy fit by saying they went too far. So it was quite a broad context, but they were going back and forth in a very contracting and expanding nature. And there was a question of what is a clear point? What is, are they doing the correct way? And when they were looking at the idea of pay and social security, they were looking at this and in relation to pensions in the Dufresne case, as we mentioned on the other slides. And that their considerations in the nature of social security benefits is not in itself excluded, but employer contributions to pension in this case were excluded from Article 157 due to the determinative nature of the state role of the state and the lack of involvement of the employer. The scheme was set up as a matter of social policy and not part of the employer-employee relationship. So it was a state pension or state-backed pension, if that's correct, because of the state involvement. It wasn't an employer aspect, so there's no difference in the pay. And is that next slide? This is just some cases looking at where the non-direct payment, the benefits in kind, were challenging the equal pay principle, that there wouldn't be no discrimination between men and women. And we're going to go through some of these cases. In the first case there, and in doing so, they do show how wide the definition of pay can be expanded. And you can see there that in Ireland, female employees could no longer enjoy travel facilities for their spouses and children following retirement, whereas their male co-workers of equivalent status could. And this was held just flat out that it was a travel benefit upon retirement. You were no longer working, but it is a benefit you were entitled to. You're not getting this just because you're a woman, while your male co-workers in similar circumstances still are. This was held to be discrimination, contrary to the treaty provisions on the matter. And excuse me, it's been a rough week. In the Kowalska case, a severance grant, so a grant upon termination of your employment, was covered by Article 57 because it was compensation to which a worker was entitled by reason of employment, even though it was paid on termination. So even though you were being paid for your job not being there anymore, that was still being paid for that job or in relation to that job. So that was still enough to put it within Article 157, that if men and women were getting different severance grants based on the sole rationale that they were, one was a man, one was a woman, that would be within Article 157. In the Seymour Smith case, compensation for an unfair dismissal was deemed to be pay, since it was designed to replace the pay which the employee would have been entitled to. So when you are unfairly fired and you take an action through the Labour Court or whatever member state's equivalent is, if there's a discrimination between the lump sum awarded between a man and a woman just on that basis, that would be a violation of Article 157. And the next ones, so they're just showing really what you're in deployment or up to the end of employment and the benefits from it, how pay can be determined. And a range of other payments and benefits have been held to come within Article 157, including several which are deemed to be statutorily required or mandated. And this is where we get a bit different, where there's rules relating to what the government is requiring the employer or the government is paying out. And this was seen then to be in the employee's interest and enough to fall within the scope of pay, as Article 157 is directly effective against the state and private employers. So if the state is discriminating as well as the employer in relation to the payments, they can take the act. Their measures will fall within Article 157. And we're going to be looking at this from how this worked. And you can see there that this contrasts though with the Gerster case. And the courts held that rules governing the length of service of public servants for the purpose of promotion eligibility, so how long you've been in the job applying for promotion, so in the civil service, I think it's 2 years or 3 years in the position before you can apply for the next one. They held that while these did affect their ability as a promotion, while these did affect and the pay that would come from the promotion, the courts held that this wasn't a matter of pay. This was a matter of equal treatment. So it wouldn't fall within Article 156. While there still may be, they may still recognize the discrimination. It wouldn't fall within the pay aspect because this is a working condition rather than the working benefit. Even though as a promotion you will be getting paid more, you have a new job, and that's they did kind of distinguish it that way. And then in the frame 2, the courts held that the fact that the fixing of certain working conditions could have a consequence was not sufficient to bring the conditions within the scope of equal pay. So unsocial conditions, dangerous conditions, undesirable working conditions, not unsafe, but just less the night shift or early morning shifts. They weren't enough to bring the matter within Article 157. They could still be in relation, they could still be working treatment if individuals of a certain class or a certain class, if they can be discriminated against and say only men are giving the prime sales hours or the prime working conditions. That's not really a pay issue, that's a working treatment issue. And that's what the courts were looking at. And when looking at this, that they looked at this from the Equal Treatment Directive 2006/56 in relation to equal treatment, that you have to provide individuals, just in those cases, in this, because we talk about men and women, you have to provide them the equal treat. You have to provide them with equal treatment in their working condition as well as equal pay. That while promotions and desirable shifts won't be within Article 157, they will still fall within the Equal Treatments Directive for the overall working conditions. So just bear that in mind of, is it a pay issue or is it a working conditions issue? That could be the grounds for discrimination. And the next two cases just I want to look at are the Bilka Cathhouse case and the Barber case, where they were looking at areas of pay and social security, because there were two significant areas. And this is looking at what would become Directive 86/378 on the occupational social security. And it was being created as these cases were going through, so they would eventually be affected by it, but not at this point. So with this, the EU legislators had clearly considered occupational pensions to be a matter of social security and not pay. And this is because it was a condition and not direct pay. They were looking at it, social security itself and not pay. They were looking at it as a more gradual approach. It took longer to actually get through. And in the Bilka Cathhouse case, the supplementary occupational pension scheme entitled was entirely financed by the employer. The scheme was adopted in accordance with the conditions laid down by the German law, but based on an agreement between the employer and the employees, bringing it within the scope of pay. Because that was an agreement, it was a condition of the employment between pay for the employees that they could argue for higher pay if they didn't accept this. And the agreement was in accordance with the statutory social security scheme. It wasn't that really the issue, that it was just because it was in accordance with that was beneficial. And the fact that you had to sign up to this itself was also not an issue, because it would be in effect for some other stuff, but not for the purpose of the Equal Pay Directive and the Equal Pay article. So it was an equal pay. It was a pay issue, because while it was a security funded by the employer, if employees hadn't have argued or negotiated for this pension scheme, they could have been arguing for higher pay. So there was that question of linking it with pay. And this then led to the Barber case, which was said to have rendered much of the 86 directive redundant. But the board held that even if an occupational pension scheme was contracted out, payments and benefits to employers constituted pay rather than social security. So they just pretty much held that again. And the EU legislation allowed exceptions to equal treatment in relation to social security, so there was allowed a difference. But because this was pay, they didn't have this exception, and companies had to remove this, the differences between pensionable ages between men and women. So where one retires and is entitled to pension, and the other may have to work longer. And what was the issue going forward with that? And when they were looking at this, the issue was whether contracted out occupational pension schemes were governed by the principles in the Framewater Book, which were they? The CJU held schemes were agreed with the employer. Schemes, then the scheme itself would not be applicable under the general categories of workers. Schemes could provide additional benefits, making it more of a supplementary scheme. So it was the scheme constituting supplementary pay because, as I said, if they had argued, if the employees had argued for higher pay, they may not have sought the pension. So what we take it at, it was a supplementary scheme, and Article 5, Article 157 could be relied upon. So if there were differences in the age of retirement, even if it's the difference of a year, that's just based on men retire at 65, women retire at 64, that's still a difference of a year claiming that pension. Still a year's worth of discrimination in relation to pay under Article 157, and it would be a breach. And in this Barber case, it had massive repercussions and fundamentally changed the way pension schemes have to be organized. And this was faced with significant criticism from both the employers and member states. Excuse me, they were arguing that the judgment itself didn't take sufficient consideration of the social policy requirement underlying many of these pensions, and it was a deliberate judicial bypassing of the legitimate piece of EU legislation. So there was a question then of, are the courts doing too much? Are the courts being too active and removing the democratic element of the EU? And when they're looking at this, the courts were quite aware that this can pose a significant risk. Not so much that they've gone too far, but they did compromise this a bit. They did compromise on the position, and they did limit the retroactive scope of the ruling. And the member states and when we're looking at the member states and had as had been entitled in light of the 1986 directive, had been entitled to consider that Article 157 did not apply to contracted out pensions. The member states say to make sure this was the way it was going and the way it would stay, actually removed they annexed the protocol in relation to treaties and included the protocol on in the subsequent Maastricht Treaty to preemptively restrict this interpretation. So the member states in when they were redrawing the treaties, they put that in because they were so concerned with this and the scope of this. It was a big step. They had to do so. And the courts, in agreeing with the interpretation, standing by its own interpretation in the Barber case, and accepting the protocol introduced in Maastricht, but they sought to limit how far this protocol could go. They sought to limit the scope of this protocol because they had the case law. They had interpreted the case law as it was, and then they sought to limit. And this was in the case of Fisher versus Burroughs, that in conjunction with the Barber judgment, and could not have that the protocol had to be read in conjunction with the Barber judgment and cannot have a scope wider than the limitation of its effects in time. And such discrimination discriminatory conditions concerning membership of schemes and other aspects of scheme benefits were still governed by the earlier body of the case law. So the courts were quite clever in this approach, and while acknowledging this going forward, they did just take a very careful glance, because the Magistrate Treaty was a significant revision. And how it worked. And this then led to the Directive on Equal Treatment, and how this worked. Sorry, knock the pages out. And this is still funny with this development. The Equal Treatment Directive under 2016 has now recast existing legislation in relation to equal pay, equal treatment, occupational security, and occupational social security. And apart from systemizing the existing legislation and codifying the case law of the CJEU at this point, it doesn't really add too much. Other directives were supposed to take up other specific directives in relation to the parental leave directive, the pregnancy directive, directive for self-employed people. They were supposed to take this at a more focus level, and that's why they didn't really do too much with it. And that is just where they are. So that's really just the directives. How the Equal Treatment and Equal Pay Directive has been redefined and redrafted and expanded out to other directives and other more specific directives for specific social and economic functions. So let's check the time. 20 minutes left. So we're just going to quickly look at Article 19 TFEU and the Article 19 directives, and how this works in relation to discrimination based on race or country of origin. And this goes back to how Article 19 TFEU was introduced following the Amsterdam Treaty as a result of a long campaign by the EU to address race discrimination and the rise of xenophobia. One thing to note, it does not contain the direct prohibition on discrimination and is not directly effective, but enables the EU to adopt measures to combat discrimination listed on the grounds listed. And you can see there, this is Article 19 in its whole. I'm not going to read it out because my voice is starting to crack. But it is quite broad. It does have the grounds, and it can combat discrimination on the grounds there of sex, racial or ethnic origin, religion or belief, disability, age, or sexual discrimination. So these are areas of grounds against discrimination you may have heard about before if you did business studies for the Leaving or Junior Cert, if you've any interest in employment law, or you might have just heard them on the news. They do come up quite a lot. So we're going to be looking at the two directives. The first one is the Race Directive 2000/43, and it established a prohibition on discrimination based on the grounds of racial or ethnic origin, and was the first one to be adopted after Article 19. And there was many concerns about the resurgence in far right in Europe at the time, and still now, even in Western Europe, though that's still an issue. Well, all over Europe, racism is an unfortunate issue, but at the time, it was a significant issue with the European expansion on the horizon and the rise of far right parties in Europe. There was a question of this has to be put in place before it becomes the significant issue it could. So it was quickly sped through the process. And Article 3, which it is very wide, it covers a significant it will apply to a significant body of areas, including discrimination in relation to healthcare, social protection, housing, and education. It also covers areas and provisions relating to private and public actors. But one thing that doesn't cover is nationalities based on discrimination with respect to third countries, pointing out the troubling relations between discrimination, race, and migration in the EU. So it's still something the EU is facing, but it was very much aimed at this is this is focusing on the anti-discrimination within Europe. If you're a European citizen, this is affecting how this will be more protecting the EU citizens than individuals coming to the EU from third countries. One thing to know as well, though, it doesn't actually define race discrimination, and this can be because it's one of those things of race discrimination when you see it, but you can't really articulate it in the black letter law, because then companies could work to get just outside of that. Technically, by strict reading, it wouldn't be racially motivated discrimination, but in practice it would. And as a result of this, it makes it very difficult to actually bring the claims forward. And this is why there's been very few references, very few cases actually being tried. And the few that they have been deemed inadmissible by the CJEU. So one of the first ones there is a FEMA Frame case. And this was brought by a domestic anti-discrimination association, not by an individual, which is interesting to note. In this case, the court held that a refusal to employ immigrants as trade people because customers might be reluctant to give them access to their home was equivalent to refusal to employ people of certain races or ethnic origin. And that's shocking to read, that people were refusing to hire certain individuals because their clients might be afraid. It's horrible to think about. Unfortunately, it did happen, and it still does. But that was equivocal to not hiring them, full stop. That wasn't a justification. And you can see there that in the Servet case, the CJEU ruled that Italians' refusal to grant an Albanian national housing benefit on the basis that he was a third country national, as Albania at that time was not a member of the EU. It still isn't. It's a candidate country, but I'm not sure of its current status. As he was the third country national, was not covered by the directive. So there was the question there of where do we draw the line between those two cases? And again, in the Belov case, the CJEU had the opportunity to rule in relation to issues of discrimination against members of the Roma community. They could have put in a stronger scope and stronger protections, but following the advice of the Advocate General, whereas held that the referring body was not a court or a tribunal, and therefore the CJEU couldn't actually answer this question. And this is maybe seen as a cop-out, that the body referring the question wasn't the correct one. Might have been some more domestic issues that why that body was referring it rather than a traditional court or tribunal. But because it wasn't deemed to be a court or tribunal within the meaning of Article 267 and the requirements for a preliminary ruling request, the courts couldn't actually answer that question. So the matter was still kind of up in the air. So the next one we're looking at, just before we start, is the Framework Employment Directive. And again, there's a interpretation on the sexual orientation, religion, age, disability, but not one on nationality. And there are a number of exclusions as well, where certain classifications of individuals under those headings, where they can be allowed. And one example of this is the member states may exclude applicants under provisions of age and disability to employment of the armed services. And when they're looking at this, the directive did not apply to state schemes such as state social security or state social protection schemes. And the directive is without prejudice to the age of retirement, and confirms the competence of the member states to determine the applicable age of retirement. So one of the things of this is certain professions might have a mandatory age of retirement. One of the ones we'll be looking at is at the mandatory age of retirement for doctors in the Marigold case, of if the doctor and a surgeon in particular reaches the age of 65, they have to retire. And the rationale they were looking at this is, unfortunately, as you get older, your skills may not be as sharp. And when you're dealing with surgery in particular, it's the very fine motor skills that you need to perform these delicate procedures. As you get older, you may not have the dexterity in your hands or your arms or whatever they use for whatever part up they need to go to perform the delicate surgery. They might, while they may still be as mentally sharp as the scalpel they're wielding, they may not be able to use it in the same manner as they could as a 30 or 40-year-old surgeon could. And because of this, there can be there can be an allowance for mandatory retirement because they may not be safe to perform these surgeries anymore. That while they may be perfectly competent as individuals, they can't perform the surgeries with the same skill and the same threshold of competence they used to be able to. And this will happen with everyone. You get older, you get, hair falls out, you go grey. It just happens. But that was one of the areas they were allowed to introduce some exceptions. I was going to also look at the Maracu case on the next slide, where the courts held that once a member state treated registration of partnerships and marriages, civil partnerships and marriages as compatible, the exclusion of partners from survivors of benefit was deemed to be impermissible discrimination on the grounds of sexual orientation. So this is in some member states where same-sex marriage in the legal sense will not be permitted. But if they allow, from a legal perspective, if they allow partnerships and marriages to have the same legal status, just using different terminology based on same-sex or different sex couples, they can't be excluded from any pension schemes the other would be entitled to. Often this isn't the case now, where many more of the member states include bringing in same-sex marriages. This is going to be an issue going forward, but it might be one that's a lingering issue for some member states. So with this, we're looking at the idea of indirect discrimination under Article 2.2.b. Whereas direct discrimination can only be justified on the basis of the exceptions in the directive. Indirect discrimination can be objectively justified if the policy reason just in a general sense, can be stood over. This indirect discrimination can be allowed to stand, it can be allowed to stay. Direct discrimination is only allowed on the grounds of the provision because they have to have a stronger application of this. They have to have a stronger definition of what direct discrimination was and the very minor grounds where this can be allowed. And yeah, so sorry, the notes. So when we're looking at this, Article 2.5 provides a generally applicable justification for different treatment that is necessary for reasons related to public security, public health, prevention of crime, public rights and rights of others, and again, public health, which we're always seeing at the moment. But again, these measures have to be justified and they have to be proportional in what they're trying to exclude. If they're trying to, if the Framework Employment Directive now wants to disallow employment from anyone from a country with COVID-19, you could say that that could be a justifiable stance. That could be where they have a significant high outbreak, or if a member state isn't taking action to stop the spread, if their plan still is herd immunity and run the businesses because we need them to stay open, that could be a grounds for public order, public security, and public health, and not allowing discrimination to stop individuals from coming from those countries. But thankfully in the EU we don't have that. All the EU member states are taking quite drastic and not drastic, well, it is drastic measures, but they're taking significant action to address it. So with Article 7 then we have the question of positive discrimination, where the provision allows the adoption of member states to permitting the adoption of preferential measures or that prevent or compensate for disadvantages linked to the groups in the directive. So if an industry has a goal of, say, hiring more women in STEM subjects, hiring, if there's two candidates who are equally valid, and there's an objective criteria where they're measured and they get the same score, the same industry could hire a woman without discrimination or without any other rationale that they were equal, but we are hiring more women to get more women into STEM subjects. That would be allowed. Another example could be men into primary school teaching, provided these are justified and objectively tested and proportional, they can be allowed. There haven't been any cases about religious discrimination at work from the case law of the European Court of Human Rights. There has been in the CJEU, but the Framework Directive can include religion. There can be other issues of equal treatment of work in relation to religion, but we're not looking at those ones today. Article 5 then is the requirement to provide reasonable accommodation for persons with disability, and that is the way it is always phrased, by the way. It is persons with disability. The reasonable accommodation has to be provided that within the employment directive, that you can't not hire a person with disability because of there will be additional renovation requirements or additional requirements that have to be granted to them. One of the ones that was quite tested before the last 2 weeks was the ability for remote working. Would that be a reasonable accommodation, or would it be inappropriate to provide remote working for persons with disability? And before this, unfortunately, it was saying that remote working isn't compatible with a large amount of industry. It isn't compatible with a large amount of work. But as we're seeing this going forward, I'm remote working right now. Refusal to allow remote working for persons with disability, short of them requiring to have an absolute face-to-face communication with clients or customers, that's going to be a very challenge. That's going to be a ground that's going to be seeing a lot of challenges going forward. Or that's just how I'm seeing it, because we're seeing how quickly businesses and life has adapted to remote working. That's going to be a large body of case law going forward if reasonable accommodation can't be made for remote working. Because, not to toot my own horn, but I think I'm doing okay with this remote lecturing style. Any feedback is always appreciated, but for other industries, remote working can be done quite easily. The resources and requirements for it aren't that arduous. We're seeing that they're being put in. Going forward, that's going to be ground and challenged. And the last thing is the directive. It sets the minimum standards, not the maximum. There's no, with these minimum standards, there's a non-regression clause. You can't go below them. Once you bring them in, they are in. But you can go as far up as you want as a member state, as you want to go with these. There's no maximum standard. But just once you bring them in, you can't go back down. So that's why member states may be a bit reluctant to go very gung-ho and very progressive with this, because they can't back down once they get to this. So we're going to stop there. The next bit we're going to be looking at is the more explicit exceptions to the directive. And I'm going to try to prepare the question for tomorrow so I can have a bit of a bit of a talk over, which is about what to do for the next question, the format, if not the actual question itself. So I'm going to stop the recording now. Where's that?